In the late 19th century and early 20th century, railways allowed previously undreamed of speed and efficiency of transportation. They were established everywhere. The Panevyzys Saldutiskis Railway was established in the Russian Empire in 1898. In 1917, the Bolshevik Revolution overthrew the Russian Empire and the Union of Soviet Socialist Republics, the USSR, was formed. The USSR immediately nationalised, or basically stole, a great deal of private property, including the Panevyzys Saldutiskis Railway. Estonia and Lithuania became independent republics, independent countries within the USSR. They were given control of state-owned assets in their territory. Estonia was given control of the Panevyzys Saldutiskis Railway and made arrangements to compensate the previous owners. They also asked Lithuania to compensate those owners for the parts of the railway which were within Lithuania. The owners were unable to obtain compensation from Lithuania, so Estonia stepped in on their behalf and initiated a case before the Permanent Court of International Justice. Lithuania objected on two grounds. First, that Estonia had no right to step in on behalf of the railway company because to take up the case of a national, the person or company had to belong to the nation at the time they were wronged and at the time of the application. At the time that the railways had been seized, there was no Estonia, so Estonia couldn't have been acting for their protection. This rule is ridiculous because it means a change of nationality can completely deprive people of the court's protection. But the court still went with it, saying Estonia must prove that at the time when the injury occurred, which is alleged to involve the international responsibility of Lithuania, the company suffering the injury possessed Estonian nationality. The second objection was that the company had not exhausted its municipal remedies. In other words, the objection was that the company had not fully pursued its appeals in Lithuania and therefore could not approach the international courts. On this question, the court essentially took Lithuania's word for the fact that further avenues were available. They said, the question whether or not the Lithuanian courts have jurisdiction to entertain a particular suit depends on Lithuanian law and is one on which the Lithuanian courts alone can pronounce a final decision. This case highlights yet again the weakness of international law in protecting individuals, even when their cause is taken up by their national government.